The man who's been convicted of killing 7 of his family members is currently being sentenced. Enoch Ndou, of course, was found guilty of those murders dating back to 2021. Giving judgment is Judge Chidada. Let's listen in.
Section 55 of the Act provides for the discretionary minimum sentences for certain serious offences. Subsection 1 thereof provides thus, and I quote, notwithstanding any other law, but subject to subsection 3 and 6, a regional court or a high court shall sentence a person it has convicted of an offence referred to in part 1 of schedule 2 to an imprisonment of life sentence. Can I close the quote? Whereas section 3 provides the following, that, and I quote, if any court referred to in subsections 1 or 2 is satisfied that substantial and compelling circumstances exist which justify the imposition of a lesser sentence, then the sentence prescribed in those subsections, it shall enter those circumstances on record of the proceedings and must thereupon impose such lesser sentence. Close quote.
Yeah, no, subsection 3 ambanga uri kote imwe na imwe kana mwatuli mumwe na mumwe kereli achikobona uri una zviitisi mavanga ane ava uri ava kombechedza uri vatseka chigwebo chine chava uri chototewa vadovara hayo mavanga kana zviitisi zvenezvo vadova hapo vaditsa kachigwebo chetu chine chava uri chototewa.
Considerations of what constitute substantial and compelling circumstances to conform with subsection 3 of section 51 of the Act shall be addressed in this judgment. The accused has undoubtedly and shockingly been found guilty of heinous and horrendous crimes. Worst of it is that what astonished the victim's family, the villagers of Jimmy Jones and the community at large was that the accused perpetrated his selfish and unnecessary killing of his own family members. The killings of which I need not overstate or overemphasize. And I insist the killing in this case were avoidable had the accused decided to implore other peaceful and legal measures to resolve his family impasse of whatever nature.
Apologies there. It seems we've lost our audio connection to the Thohoyandou High Court.
His incarceration remains a father figure who was expected to lead the family by example in his capacity as a paternal uncle to his victims whom he shot to death.
breke ine yava uri ova nachiwo chishushaho kukuma ombe unavona wouri vava mamombe yove mutu ane vana vavakomana vavo vova vachidivasedza sakotsi ane ava uri vafanira uri vadove havo ive vone vanoranga phanda hangei mudini.
That on its own aggravates the seriousness of the crimes the accused is convicted of. It becomes a serious concern not only to the community or the nation at large, but a greater concern to the court of late to deal with increasing criminal matters of offences committed by family members within their homestead against their own. Committing such offences within the spaces ordinarily expected to be their haven of safety. It therefore comes as no surprise to this court that the citizens of our country are outraged by criminal conduct of similar nature that provokes some of them to become emotional and decide to take law into their own hands. Something which is constantly condemned and discouraged by the courts and our law enforcement authorities. For a simple reason, I reiterate that, open quote, two wrongs do not make a right, close quote. In State versus Malchus 2001, Volume 1, SACR, at page 469, the Supreme Court of Appeal decision, the court emphasized the principle that sentencing resides preeminently within the discretion of the trial courts, of which such discretion is to be exercised judiciously so. It is therefore a trial court's responsibility and legal obligation following conviction to impose an appropriate sentence on an accused person of which, considerate of the circumstances of the case, can only be a custodial one. In State versus V, in 1972's decision at Volume 3, South African Law Report, at page 611, the Appellate Court's decision, Holmes J.A. held thus, and I quote, punishment should fit the criminal as well as the crime. It must be fair to the society and be blended with a measure of mercy, close quote. I emphasize that interest of the victim's family should play a pivotal role amongst the factors to be considered and taken into account when the trial court considers what an appropriate sentence to impose on the accused should be. However, This court is alive to the distinction of the triad factors regarding retributive, deterrent, and the rehabilitative measure that the sentencing court must infuse in its punishment of a convicted accused in terms of the classic decision of State versus Zin, a 1969 decision. In the decision of Malchus, State versus Malchus, cited supra, the court emphasized that the specified statutory and mandatory sentences prescribed by the Act should not be departed from, being imposed by the trial courts lightly and for flimsy reasons which cannot withstand scrutiny. Save for where the trial court finds substantial and compelling circumstances in favor of the accused, justifying imposition of a lesser sentence on him or her other than the one legislated in terms of the Minimum Sentences Act. Notwithstanding, the state proved no previous criminal records against the accused prior to the recent conviction in this matter. The accused has only had his first brush with the law when he was already above the age of 50 years old. Something which, in my view, is commendable of him. However, age does not negate that crime can still be committed at any age and at any time of one's life. State led the evidence of Thohoyandou Ndou in terms of Section 274 of the Criminal Procedure Act prior to the passing of the sentence in order to inform the court of the impact the accused's conduct has caused his entire family. Particularly the despicable devastation the accused killing of family members has caused agony on his mother. The agony of his mother losing his own children, grandchildren that the accused has made her to live with for the rest of her life. Mr. Thohoyandou Ndou testified that much as the family welcomed the conviction of the accused, regardless, the family remains deeply hurt to this date, and they all still cannot understand why their own uncle would do such a horrible thing and resort to killing his own late elder brother's children and grandchildren. Astonishing was that the accused himself, after the passing of his elder brother, he even assisted to raise the same victims that he killed on Christmas Day or Christmas Eve of that particular year. Patuani recalled how difficult it was to arrange a funeral to bury 7 members of the same household all at once. He indicated that they received and had to rely on local government and the extended family members' financial contributions. He, as one of the elder sons in the family, had to make plans to source funds through unplanned loans to make sure that the burial continues and his loved ones are laid to rest with the dignity they deserved. To that end, he stated that the accused did not make any contribution towards the funeral. Witness further testified that to this stage, the accused has never even attempted to convey any apologies personally or otherwise. Which, according to him, the witness is indicative of the accused's lack of remorse to a lifetime evil deed he caused the family. He indicated that he and other family members are assisting his mother to raise Funzo, his late brother's only surviving child. Emotional wise, he indicated that the family has decided not to further talk about the shooting ordeal in the presence of Funzo. He stated that the minor child is currently 12 years of age. The reason why they resorted from not talking about what has befallen their family was that they don't want Funzo to recall and probably relive his devastating experience and dwell on thinking that he was an orphan. He further stated that the homestead remains unoccupied because no one lives there any longer.
Often.
Ms. Nkata, did you capture that? Let's continue. He further stated that the homestead remains unoccupied because no one lives there anymore. All the people who resided there are deceased at the accused bloodied hands.
Who is not an orphan? Who is not an orphan?
According to him, they ended up demolishing the structure all the deceased used to occupy at his mother's plea and request in order to assist her in the long journey to recovery from what has befallen her. To this date, they are still battling to come to terms with their loss. It has not yet crossed their minds whether to forgive the accused or not, but according to him, only time and future will tell. In aggravation of sentence, the state counsel argued that the offenses committed by the accused were, according to the state, premeditated and was carried out in execution style. Whilst the accused was using his personal automatic pistol.
To South African judiciary and prosecution. It's a shame.
The execution style was whilst the accused was using his personal automatic pistol. From the evidence presented by the state before court, it was apparent that the accused had already formulated an intention to kill Mpo, the deceased, in count 1. At least when one has regard to the threats the accused had made to few family members that he was going to kill him on numerous occasions before the actual incident. As a result, the state prayed that the provisions of Section 51, subsection 1 of the Criminal Procedure Act was applicable and that the state had made a proper case for imposition of life imprisonment on count 1 against the accused. The state urged the court to follow the principle enunciated in State versus Malchus, in that this court should avoid deviation from imposing the prescribed sentence for flimsy and hypothetical reasons that may be advanced by the accused. This court was implored to impose severe sentence to serious crimes equal to the current case. The court was equally urged to be circumspect when considering factors submitted by the accused to be substantial and compelling in his favor to evade the wrath of the prescribed minimum sentence. State was, however, not opposed to the sentences to be imposed on other counts to run concurrently with the life imprisonment sentence they so pray to be imposed on count 1, since all the offenses were committed at one instance. In mitigation of sentence, defense counsel submitted that the accused submitted the accused personal circumstances as follows. That the accused is currently 56 years old, unmarried male. 6. And was 52 years old when he was arrested after committing the offences under consideration. The accused was a professional nurse employed by the Department of Health, attached to Mafikeng Provincial Hospital's intensive care unit before his arrest. Attached to the intensive care unit. He was gainfully employed with a monthly income of just over 30,000 rand. He is reported to have owned about 17 immovable properties in a form of vacant land or stand in and around Malamulele and Guyani traditional land or area. Counsel further informed the court that the accused before his arrest owned about 7 motor vehicles, most of which were parked at his other brother's homestead. He was reported to have owned and sponsored 3 local soccer teams within the vicinity of his rural villages. This background to me undoubtedly demonstrated a man of financial means in accused caliber. Not only financial, but also of sufficient intelligence that earned him a position in a hospital's intensive care unit until his arrest. Counsel requested the court to consider the accused's bipolar condition, which was temporary in nature, to be, or as his substantial and compelling circumstances in favor to qualify him a lenient sentence. It was, however, not disputed that such a condition did not affect the accused's employment in any way. Defense counsel considered when quizzed by the court that premeditation can be inferred on accused's commission of the offense on count 1. That was because of the uncontested, constant prior threats the accused made about killing Mpo, the deceased in count 1, to some of the members of the family. It was, however, counsel's submissions which I unreservedly agree with, that the shooting and killing of other deceased family members was clearly unplanned nor premeditated.
Inga nawo zora ro do ko basindisa uri zone botendelana uri kamisi haya mabula ya aba bamwe shingaba sungu tuma zafulani.
Instead, they seem to have occurred in acute spur of the moment of anger. It is therefore my conclusion that the state failed to prove that the accused stands to be sentenced to life imprisonment in terms of the prescribed legal framework. Our courts have refrained from providing an extensive definition of what constitute exceptional circumstances. In State versus Jonas, 1998, Volume 2, SACR, at page 677, the court held the following, and I quote, "The term exceptional circumstances is not defined. There can be as many circumstances which are exceptional as the term in essence implies," close quote. In State versus Mazibuko and another, a 2010 decision, Volume 1, South African Criminal Law Report at page 433, the KwaZulu-Natal Province decision, the court stated that for a circumstances to qualify sufficiently exceptional to justify the applicant's release on bail, it must be one which weighs exceptionally and heavily in favor of the applicant. Thereby rendering the case for release on bail exceptionally strong and compelling, close quote. To this extent, the accused remained timid and showed no sign of contrition towards his gruesome deed of murdering his own family members, literally his own children. I therefore find that the accused's personal and mitigating factors cumulatively considered are not extraordinary and inordinate. To compel this court to deviate from applying the minimum sentence of life imprisonment, at least on count 1. In essence, after considering the totality of the evidence before me, I have concluded that the accused's mitigating and personal circumstances are far outweighed by the aggravating circumstances inherent in the state's case. As alluded above, I cannot overemphasize the seriousness and the brutality of the offense the accused has committed. Neither can any sentence that may be imposed by any court of law can reverse the loss the accused has caused his family.
chifhio na chifhio ahuna chine changavuyisa kana kudzhia murahu zvine zvava uri vamuta vofira khazvo.
What is certain, though, is that the law has to take its course and severely punish the accused within the prescripts of the law.
Chine chatova uri chione changondi cha uri mulayo ufanira ushuma utove hapo unecheze chigwevo kana khaturo ine yava uri idova ichikochimira na mulayo.
The excruciating pain the accused evil deeds caused into the deceased surviving mother's heart is in reality unimaginable by others. But an everlasting pain, in my view, she will endure for as long as she lives. The accused therefore deserves no punishment other than a direct custodial sentence that will remove him from the society for a lengthy period of time, for he has not only presented himself as a danger to his own family, but to the community and nation at large. Finally, I find that the accused should never again be authorized to possess a firearm and ammunition if he gets an opportunity to. The firearm license which was initially issued to him should immediately be revoked, and the personal firearm issued in his name to be forfeited to the relevant law enforcement authority. Regardless of how we all or some look at it, our country is under siege of crime. The general citizenry is understandably outraged by endless and senseless killings similar to the one the accused is convicted and about to be sentenced of. Therefore, the court's pursuit to curb the scourge of crime by imposing appropriate imprisonment sentences on offenders convicted of serious crimes shall be the only option. However, the court must always confine itself to uphold the rule of law to reduce the advent of lawlessness emerging in our country. The accused may now stand. Consequently, the accused cannot avoid the inescapable conclusion that he deserves and stands to be sentenced as follows. On count one, the murder of Enoch Ndou, the accused is sentenced to life imprisonment. On count two, the murder of Enoch Ndou, the accused is sentenced to 15 years imprisonment. On count 3, the murder of Georgina Poshia Chauke, the accused is sentenced to 15 years imprisonment.
Mulandu wa vuraru une wa bauri ndi volaela Georgina Poshia Chauke ndi miṅwaha ya 15 nga ngomu.
On count 4, the murder of Rendani Enoch Ndou, the accused is sentenced to 15 years imprisonment.
Mulandu wa vuna une wa bauri ndi volaela Rendani 15 years nga ngomu.
On count 5, the murder of Dakaro Makondo, the accused is sentenced to 15 years imprisonment.
Mulandu wa vutanu une wa bauri ndi volaela Dakaro Makondo chitoro chaone ndi miṅwaha ya 15 nga ngomu.
On count 6, the murder of Ronewando, the accused is sentenced to 15 years imprisonment.
6 une wa bauri ndi volaela Ronewando 15 years nga ngomu.
On count 7, the murder of Wangando, the accused is sentenced to 15 years imprisonment. It is ordered in terms of Section 280 of the Criminal Procedure Act that the 15 years imprisonment sentences imposed on counts 2 to 7 are to run concurrently with the life imprisonment sentence imposed on count 1.
No, hapo vanenda era ya ureme zvigovo izvi zva 15 years ubva kamanda uviri usvika kamanda wa 7 idochimbira yo pekati na chigovo chine chava uri chamanda wa kutoma chine chava uri chakuchiro avo utenga ngovu.
The accused is therefore sentenced to an effective sentence of life imprisonment.
Zvino zviamba zva uri muwewa uri vana na chigovo chine chava uri chakuchiro avo utenga ngovu.
The accused is further declared unfit to hold or possess a firearm license, firearm and ammunition in terms of Section 103, subsection 1 of the Firearms Controls Act, Act number 60 of 2000. That concludes the sentence proceedings against accused Mr. Enoch Ndou.
As a conclusion. As conclusions, Madam.
Thank you very much. That brings us to the end of today's sitting. The court will then take an adjournment for a day. Court agents.
All right, court.
All right, and so there you have it, live visuals there coming from the Thohoyandou High Court. That's where the sentencing proceedings of Enoch Ndou has just wrapped up. He's essentially been slapped with an effective life behind bars for the killing of his 7 family members. For count 1, that's of one of the relatives, he was given life imprisonment, whilst counts 2 to 7, he was given 15 years behind bars. Effectively, these will run concurrently, meaning that he'll essentially have to serve a life imprisonment, which I think amounts to about 25 years, if my memory is anything to go by. But quite a lively time, I suppose, inside court, as he had multiple outbursts as that sentence was being read out, at some stage casting aspersions on the country's judiciary and the justice system. And of course, this will, I suppose, raise all kinds of questions about his mental health, which was raised, by the way, throughout the course of this particular trial. But Judge Togomelani Chidada really being unscathing, not mincing his words as he delivered that judgment, saying the accused never showed any signs of remorse. He killed his late brother's children and grandchildren, execution style. The murders we heard seem to have been premeditated. The family, when they gave evidence in this trial, saying he hasn't tried even once to reach out to them to apologize for what happened. The accused, says the judge, undoubtedly found guilty of shocking crimes. These killings cannot be overstated, and they were avoidable. At the heart of this, we understand, was a family dispute over the ownership of a house, it seems, that has seemed to have run through several generations. The judge saying, in fact, there were other ways, of course, to deal with that particular disagreement. He didn't need to state that. I think most people will certainly agree. And we'll get a sense of what happens next. It seems he also had a license for a firearm. This particular court ruling that, in fact, that license should be revoked. We'll certainly get you a sense of what else came out of that. Pimani Baloyi is part of our team watching that story, and I have no doubt she'll try catch up with the family that has to deal now with the loss of 7 of their relatives in this brutal way.